Hello there. Have you ever used a rideshare app like Uber or Lyft? Many of us have, but many people living with disability have not experienced equitable service. The Rocky Mountain ADA Center, with the help of the University of Northern Colorado, put together relevant information for people with disabilities, so they know their rights under the ADA when it comes to using rideshare transportation apps. Under Titles 2 and 3 of the ADA, publicly and privately operated transportation entities that serve the public must provide accessible services for riders with disabilities, including where a public entity contracts with a private entity. Private entities that are primarily in the business of transporting people and whose business affects commerce are considered subject to Title 3 of the ADA. But Uber and Lyft do not categorize themselves as transportation providers. Instead, they self-label as technology companies. Courts have disagreed with this and consider Uber and Lyft to meet the definition of a transportation provider. This specific issue has not been addressed on a national level. People with disabilities rely on rideshare apps more than people without disabilities. Riders report challenges with Uber and Lyft related to drivers' failure to accommodate a rider's disability. Riders report disability discrimination based on use of folding wheelchairs and service animals, how long it takes them to get into an Uber or Lyft vehicle, lack of accessible vehicles for larger mobility devices. In 2020, Lyft settled a case in which they were sued by riders with foldable wheelchairs or walkers for discrimination. They claimed that Lyft drivers refused rides on multiple occasions because of their wheelchairs. The settlement ordered Lyft to revise its mobility device policies, communicate these policies to drivers quarterly, and provide an educational video for drivers on how to accommodate mobility devices. Lyft stated that it would create a complaint procedure for riders to report when drivers discriminate against them based on their use of a mobility device. In another case, 3 motorized wheelchair users sued Uber under the ADA in California. They argued that Uber choosing to not offer wheelchair-accessible vehicles, Uber Wave, in their cities was discriminatory. Uber Wave is a program specific to the needs of mobility devices that are too large or heavy to transport in non-specialized vehicles. They claimed that Uber effectively screened out riders with mobility disabilities from enjoying particular transportation services. Uber argued that providing Uber Wave in additional cities would constitute a fundamental alteration to the company's services, which the judge rejected. Uber first argued that the ADA did not apply because it is a technology company, not a transportation company, which the judge rejected. The wheelchair users argued that providing Uber Wave in their cities was an appropriate, reasonable modification to accommodate their disability-related needs. Uber argued that the request was not a potential reasonable modification under the ADA, which the judge also rejected. Uber then argued that even if the request was a proper, reasonable modification request, it was still unreasonable, which the judge agreed with. The judge considered the cost, feasibility, and other factors, then concluded that the plaintiffs did not provide enough evidence to demonstrate that bringing Uber Wave to their home cities was feasible. Practically speaking, these decisions mean that riders are unlikely to be able to require Uber or Lyft to develop wheelchair-accessible services in particular cities, under the theory of reasonable modification. Complainants lost a similar case in a class-action lawsuit against Lyft in New York in 2024. A federal judge concluded that Lyft did not violate the ADA by not offering its Wave services in the region where plaintiffs lived. The lawsuit argued that Lyft didn't provide reasonable modifications and failed to remove transportation barriers in existing vehicles under the ADA. The court determined that plaintiffs' desire for Lyft to expand its services was not a reasonable modification request. It instead concluded it would alter Lyft services, which the ADA does not require. The U.S. Department of Justice sued Uber in 2021 for disability discrimination rooted in the company's wait time fees. At the time, when an Uber driver arrived, the company required a rider to get into the car within 2 minutes. If more than 2 minutes passed, the app began collecting fees based on how long the driver had to wait for the rider to get into the vehicle. It did not account for if the rider took longer to enter a vehicle because they had a disability or not. Lyft imposed similar fees for long wait times. As a result of the lawsuit, Uber allowed riders to self-certify that they had a disability and could request a refund for any wait time fees they were charged. Lyft offers a similar refund service. Riders who use service animals report frequent problems with rideshare apps. Riders frequently have drivers refuse to allow their service dogs in the vehicle. Uber and Lyft charge a fee if a rider requests a trip and does not show up for a ride within 2 to 5 minutes of the driver's arrival. A woman named Suzette May, who is blind, has had drivers wait for a full 5 minutes to trigger the app to automatically consider the rider a no-show and then tell her they will not allow her service dog in the vehicle. Both Uber and Lyft have policies allowing service animals, but people with disabilities still experience discrimination attempting to ride with their service animals. Uber and Lyft require users to agree to an arbitration provision when users sign up for the apps. This requires users to waive their rights to a jury trial and instead resolve disputes outside of court. Riders can get relief through this arbitration process. For example, a California resident received over $324,000 in damages plus attorney fees after Uber drivers had refused her service dog several times. The National Federation of the Blind also reached a settlement with Uber and Lyft based on discrimination related to service animals. Uber and Lyft have made various changes to their services to better accommodate people with disabilities by providing accessible vehicles, in-app accessibility, and updated service animal policies. Both Uber and Lyft have created wave ride programs that accommodate motorized wheelchairs. However, these services are only offered in select locations. Wave program vehicles must accommodate a motorized or fixed-frame wheelchair or larger non-foldable mobility device. Wave vehicles typically offer ramps, lifts, and securement equipment. Uber and Lyft offer Wave services at the same payment rate for riders as non-Wave rides. According to Uber, Uber Wave vehicles have completed a third-party service and safety certification. Uber Wave is only available in Chicago, New York City, Philadelphia, and Washington, D.C. Riders with Uber Wave may bring as many companions as there are seats with seatbelts in the car, just as riders in other Uber vehicles may. Riders do not need to pay for additional companions. To request a Wave ride, a rider uses the Uber app and selects Wave when requesting a ride. Drivers are otherwise only trained to ask before handling wheelchairs. Lyft created a similar Wave program called Wheelchair Rides and currently offers the service in Boston, Chicago, Dallas, Los Angeles, New York City, Philadelphia, Phoenix, Portland, San Francisco, and Toronto, Canada. Some included features of the Uber and Lyft apps are helpful to riders with disabilities. For example, the apps allow riders and drivers to communicate either verbally or through text message, allowing riders with visual or auditory disabilities to use their preferred communication method. The apps provide visual and haptic notifications, so a rider knows when a ride is nearby and when it has arrived. The Uber app has a feature that allows riders to self-identify as blind, deaf, as having a visual or auditory impairment, or using a service animal. Uber and Lyft have implemented service animal policies that reference both state and federal law regarding disability. Riders with disabilities are allowed to bring their service animals in both Uber and Lyft rides. Riders with service animals should only expect to answer 2 questions regarding their service animals. 1, is this animal required because of a disability? And 2, what work or task has the animal been trained to perform? Riders should not expect to provide any documentation for their service animal to a driver. Riders should also not expect an emotional support animal to be accommodated as a service animal. Riders using Uber have the option to self-identify as individuals with service animals in the app, allowing drivers advance notice. Lyft also offers riders the opportunity to voluntarily disclose if they have a service animal traveling with them. If a rider who uses a service animal has a bad experience with Uber or Lyft, they may file a complaint with either company. The complaint might allow a rider to get a refund for the ride or credit with the company. A complaint might also lead to deactivating a driver's profile and not allowing that driver from working for the company. Uber states that any rider that has issues with ride cancellations, harassment, and improper cleaning fees related to service animals may report a complaint. Formal complaints can also be filed with the United States DOJ under Title III. Despite policies stating that drivers are subject to ADA requirements, riders with disabilities still report ride cancellations, cleaning fees, and other problems. Much of the law involving Uber, Lyft, and the ADA is unsettled. Despite attempts to make their services more accessible, riders with disabilities continue to report discrimination and challenges in using the apps. Approximately 15 states and Washington, D.C. have expanded their paratransit programs by using a rideshare company that is specifically tailored to providing services for people with disabilities, called UServe. There are promising legal arguments to demonstrate that both Uber and Lyft are subject to the ADA and that riders are entitled to protection from disability discrimination. For more information on the ADA, please reach out to our team. Email at rockymountainada.org or 800-949-4232, and we'll be happy to discuss what's on your mind. This report was compiled by Maeve Moynihan, JD, University of Denver Sturm College of Law, and Jill L. Bachiak, PhD, Professor, University of Northern Colorado, and condensed into a knowledge translation format by Chris Murphy, Rocky Mountain ADA Center. The contents of this video were developed under a grant from the National Institute on Disability, Independent Living, and Rehabilitation Research, Neidler Grant number 90DPAD0014. Neidler is a center within the Administration for Community Living, ACL, Department of Health and Human Services, HHS. The contents of this video do not necessarily represent the policy of Neidler, ACL, or HHS, and you should not assume endorsement by the federal government.